Hello, welcome everyone to the webinar China and Brazil Management, Investment and Risks. My name is Guilherme Amaral and I'll be moderating this event along with Lisa Zhang. We have people joining from all over the world today, from Ho Chi Minh to São Paulo, from Manila to London, Istanbul, Beijing, Dubai, Kathmandu, New York, you name it. So thanks everyone for joining. Brazil is a land of opportunities for foreign investors owing to its huge domestic market, a clean energetic matrix, strong institutions, and respect for the rule of law. China is Brazil's main investor and largest commercial partner since 2009, with investments in many sectors. So I hand it to you, Elisa.
Yep, that was beautiful there. So Guillermo and I put together this event to promote awareness of the opportunities and challenges of Chinese-driven investments in Brazil, to demystify the way in which these investments are structured and the legal landscape of governing them, and to offer you the facts to dispel common misconceptions on these investments and on Hong Kong as an arbitral seat, notwithstanding the latest developments in relation to the protests and the national security law. So I am a member of the Hong Kong Dispute Resolution Team at Fangda Partners, a premier full-service Chinese firm able to advise on common law in Hong Kong as well as civil law in China, where foreign firms cannot advise in Chinese law. So we are able to provide seamless service to our clients in all aspects of their businesses. And I have a particular interest in the intersection of Latin America and China, having grown up in Panama and have developed a specialty in commercial arbitration involving Latin American countries, LATAM, and Latin American parties and Chinese counterparts.
So I think I can speak a little bit about myself as well. I am a partner at Souto, Correa Advogados in Brazil. My firm, we're a full service firm. We have offices in São Paulo, Brasilia, Rio, and Porto Alegre. Myself, I specialize in arbitration, international and domestic arbitration. I am also a member of the ICC Belt and Road Commission, and I'm usually handle many cases for Chinese parties in Brazil. So I think we can start now with the presentation of our speakers. So I'll start by presenting Luis Peretti to all of you. Luis helps Brazilian and foreign clients overcome disputes through mediation, arbitration, and litigation. He also works on conflict prevention, drafting contracts, and devising efficient dispute management strategies. Before joining our firm, Souto Correa, Luis acquired experience in foreign law firms, having worked in arbitration, sitting in several jurisdictions and administered by the major dispute resolution centers worldwide. He also served as a Secretary General of the CSPS Chamber of Conciliation, Mediation, and Arbitration in São Paulo. So he's going to bring us this perspective as well. Fernanda Girardi is a partner from Souto Correa Advogados. She's a corporate lawyer whose practice mainly focuses on commercial and infrastructure contracts. She provides counseling to domestic and foreign companies in a number of infrastructure projects involving thermoelectric, hydropower, and wind power plants. She has been advising Chinese clients which develop infrastructure projects in Brazil for more than 15 years. She also takes part in arbitrations involving contractual issues, and she has a master's degree in private law from the Federal University of Rio Grande do Sul, where she also attended as a professor.
So Mr. Ben Miao is based in Shanghai. He's the Chinese disputes expert of today's panel. So he is a DR partner specializing in multinational corporate clients in their China-related commercial disputes, primarily in regulatory investigations, corporate governance, insurance disputes, asset recovery, and arbitration. Before Fangda, Ben spent a number of years in a leading UK law firm in Hong Kong and Shanghai. Mr. Michael Tam is based in Hong Kong, and he is our M&A expert of today. He specializes in cross-border M&A, real estate development, infrastructure, and energy projects in China, Southeast Asia, and Africa. and many other regions as well. Prior to joining Fangdang in 2015, Michael was the founding partner of Berwin Leighton Paisner in Hong Kong office and has worked for the Hong Kong offices of Clifford Chance and Linklaters from 1996 to 2010. Ms. Sarah Grimmer is our arbitral institution expert of the evening or day, depending where you are. She's the Secretary General of the Hong Kong International Arbitration Center, and she was formerly the Senior Legal Counsel of the PCA, and prior to joining the PCA, the Permanent Court of Arbitration, and prior to joining the PCA, Sarah served for 3 years as Assistant Counsel at the ICC International Court of Arbitration in Paris. So that is our panel today. Before we start, I wanted to invite all of our attendees to submit their questions as we go. So this panel has been designed in a Q&A format to promote conversation. So we opted not to have formal presentations with lengthy PowerPoint presentations. So I think in order to achieve our goal of keeping it interactive, we encourage you to submit questions, whether you're joining us from Zoom or from YouTube. So please don't be shy, submit your questions. Thank you. So I think the first topic, Guillermo is going to kick it off.
Okay, so the first topic is legal and commercial challenges when investing in Brazil and China. So I'll start by asking Fernanda. Fernanda, you've been assisting Chinese clients in Brazil for the past 15 years. Can you give us an overview of these investments, focusing on the specific sectors that they've happened? Do you see any trends or new opportunities arising for Chinese investors in the future?
Sure, Guilherme, and I would like to initially greet everyone who is following us from all around the world. And it's a pleasure to be here with our colleagues from Fanda Partners and also from the Hong Kong International Arbitration Center. I think it's first important to mention, as Guilherme commented, that China has been the largest trading partner since 2009 from Brazil. And although today we are not talking about the trade relationships between countries, this fact demonstrates the relevance of our relationship. So to answer your question, Guilherme, I would like to start by quickly sharing some data on direct investments in Brazil from China, US, France, Italy, and Japan. And this data was gathered by the Brazilian Ministry of Economy. So I will quickly share my screen so that you can follow. Okay, so here you can see in this first slide that we have this report, as I commented, it's from CAMEX, which is a state body, a foreign chamber of commerce that belongs to our Ministry of Economy. And this report, it was issued in April 2019. The first slide provides an overview of the confirmed foreign direct investments made in Brazil from 2003 to 2019. China is represented in the red bar. Over the last decade, the most significant amount came from US and France. However, since 2010, there has been a clear predominance of Chinese resources. In the second slide, let me just quickly go through. In the second slide, we can see the number of projects and the respective amount invested. And again, China is represented in red here. And although we can see that that Chinese projects are fourth in the number of projects, when we analyze the value of the projects involved in the investments, we can see that between 2003 and the first quarter of 2019, the direct investment from China accounted for 38% of the total investments made by these 5 countries. and China is in the first position. So the differences between these scenarios, let me just return here. So we can see that the difference between the comparison of the values and the number of projects largely reflects the size of the projects and the sectors of destination. Now, if we look to the past 10 years, we can divide the scenario of the Chinese investments in Brazil into 4 phases. I would say that up to 2010, we can identify that the main interest of the Chinese investor was in commodities field, especially due to China's increase in demand for products such as oil, mineral, and soy. Afterwards, from 2011 to 2013, the investments focused on the industry and consequently on the consumer market. Here, I would highlight the machinery, automotive, and also electronic equipment sectors. Then in 2013, we had the third phase, the beginning of the third phase, where we can see that the investments focused more on services and especially in banking. And in the fourth phase, which started in 2014, we can see relevant investments in energy, infrastructure, and agribusiness, especially in 2017, when Chinese investments amounted to $9 billion, most of which related to energy assets. In 2018, we experienced a reduction of Chinese investments, which is connected to the Brazilian political scenario and the presidential elections here. I would say that foreign investments in general decreased in 2018 due to such uncertainties. In 2019, Chinese investments grew again and reached 1.9 billion, much superior to the almost 300 million invested in 2018. Evidently that good perspectives had been outlined for 2020, especially in the field of infrastructure, such as roads, ferries, ports, and airports. But yet, unfortunately, the COVID-19 pandemic hit all of us and brought some adverse effects to the scenario, not only in Brazil, but worldwide, as we all know. But of course, it's not all bad. And I would say that we can look to the future and we can see some clear opportunities opening to Chinese investment. And one sector that I would highlight is sanitation. According to the data available in the Brazilian National System of Information about Sanitation, in 2018, the sewage system in Brazil only reached 50.2% of the population. So this field has now become attractive for foreign investments because Brazil has recently saw the enactment of a legislation that incentivized the entry of private investment in sanitation, which used to be most operated by state entities. So based on this new regulation, the sanitation sector will be much more open to private investment, I would say. In fact, state-owned companies will now compete with the private initiative and private investments. Other interesting sectors and for further Chinese investments are energy, infrastructure, oil and gas, construction. And as you know, China already has an increasingly strong presence in Brazil in the field of electric energy, with the entry of relevant players in generation, thermoelectric, hydroelectric power, transmission, and also distribution systems. And now a growing trend in Brazil is renewable energy, which encompasses wind farms, biomass, and also solar energy. So the Brazilian market is seeking new investments in this field, and which has even been receiving some incentives given that it's a clean energy. I would highlight that urban mobility is yet another opportunity for the investment, and Brazil is in deep need of creative transportation solutions because our urban mobility system is overwhelmed in the large metropolitan areas. We can see the example of Didi, which entered in the market in 2018 through the Brazilian company that was incorporated, the 99. And along with Uber, they revolutionized the system for transportation apps. And 99 also offers ride sharing, and more recently started to offer traffic assessment services. Another trend, which is not only a Brazilian one, but global, concerns technology. And here there are several segments which would certainly benefit from technological solutions. So a good and current example would be healthcare and our pressing need for COVID-19 solutions, such as thermal monitoring system, for instance. So in a completely different field to end, but equally promising, I would say, is fintechs. Whose most promising example is Nubank, that was recently incorporated by Tencent. So fintechs have been revolutionizing and expanding banking services around the world. And this is a window wide open for China as well. So this would be the past scenarios and the opportunities that I would like to highlight for the coming years.
That's very good, Fernanda. You've told us about opportunities in Brazil, which are many, but there's also an old saying in our country, which is Brazil is not for beginners, or Brazil is not for amateurs. And this old saying speaks of the intricacies of our legal system, the ever-changing nature of our politics. So you've spoken about the challenges, but about the opportunities, but what about the challenges, especially the legal challenges for Chinese investors in Brazil?
Yes, indeed, Guilherme. Brazil is not for amateurs because our system is complex and there are several peculiarities to be considered for an investment to be done. So from the legal perspective, I would like to point out some risks arising from four main fields, which are environmental, tax, labor, and corporate. So from the environmental standpoint, I would say that the main risk is the Brazilian environmental laws, which are very rigid and strict in terms of liability. But I would say that the main difficulty in this field for a foreign investor is the fact that all spheres of our public entities in environmental matters, they are entitled to legislate on environmental laws and statutes. So to illustrate this scenario in numbers, to give more concrete examples, Brazil is made up of 27 federative units, so 26 states plus one federal district, and more than 5,500 municipalities organized within those states. So in Brazil, as I said, both the federal and the individual state governments can concurrently legislate on environmental matters. So the federal government establishes general rules, while the states and the federal district, they enact special regulations. Municipalities can also supplement those federal and state laws and can also legislate on environmental matters to cover local interests. So as you can imagine, this scenario is even more intricate when we have projects or ventures that cross borders. So another issue that I would like to highlight is that there are several agencies, several entities that are entitled to regulate license and to oversee the activities performed by corporations. And such agencies, they have autonomy even regarding to the interpretation of the regulations and how to apply the requirements for the environmental laws. And now this scenario brings us to the final point that I wish to make. This lack of standardization of the requirements, they cause licensing procedures to be quite time consuming, and they can impact the commencement of the operations. So therefore, when planning a project in Brazil and determining its location, it's highly recommendable that the investor be fully aware of the federal, the state, and any local regulations, and of the competent regulatory agencies that will be involved and how they operate and interpret the issues at hand. As to tax issues, moving to tax issues, our scenario in Brazil is to some extent similar to environmental one, but there's no unified taxation. So, and I would like to highlight an important difference. The competence of the federative unit does not overlap, which means that the federal, state, and municipal spheres are competent to levy taxes on different and specific hypotheses. For instance, the federal entity will tax income, the states will tax the commercialization of products, and the municipalities will tax services. So again, it's crucial for an investor to know how the system works, because the way a project is structured will have direct impacts in taxation. Regarding labor aspects, it's important to be aware that Brazil has a strict and protective legislation, and knowing the applicable rules for a specific sector is also relevant, as well as knowing the union that has jurisdiction over the group of employees, which is defined by the location and type of activities that is performed, because the main goal of the workers' union is to ensure some additional benefits, is to state some regulations through collective bargaining agreements. The employers usually do not have flexibility to choose the employment regime, and there is a relevant burden over the remuneration to be paid. So this means that the cost of any given employee is at least 1.7 times his or her base remuneration. Another relevant issue is the liability of the employer in the event of succession. When an investor incorporates an existing company, it assumes the liability for any past labor debts, if there is any. So this brings us to the fourth and final field, which would be the corporate issues. How to operate in Brazil. I should first point out that although possible, it's not common practice in Brazil to simply set up a branch of the foreign parent company, because this option requires being granted some specific authorization from the government, and this is not simple at all. So the main two options for investors are to either set up an entirely new company, a subsidiary in Brazil, or to incorporate an existing Brazilian one. And there is no right or wrong when choosing which alternative would be the most appropriate. It's not only crucial that the investor analyze the rules applicable to the specific sector in which the company will operate, but it's also important that the investor be fully aware of any particular restrictions regarding the entry of foreign investments in that sector, such as aviation, media, mining, which have some specific conditions in Brazil. So in addition to that, deals on regulated markets, they also require some prior approvals by the regulatory authorities, such as energy, health insurance. It's also important to bear in mind that foreign investments must necessarily come through the Brazilian Central Bank, which requires a specific registration for this purpose. So that said, I would say that there are two main factors to be taken into consideration when deciding to go new or to incorporate. One is the challenge of adapting to sometimes different company cultures. And the other one is the fact that the investor assumes liability for any existing contingencies, past liabilities of the company to be incorporated, unless such acquisition occurs through in a company reorganization procedure. Now, this would make it sound like setting up a new company would always be the best alternative. However, we cannot forget that incorporating an existing company provides the benefit of entering into the market more easily, because part of the process has already been handled in advance. So whichever the choice may be, knowing the applicable rules for sectors and running a due diligence are vital to mitigate any risks for the venture. And we can discuss these items further in our Q&A, but these are the main points, the main issues I wanted to bring to your attention.
Yeah, thank you, Fernanda. That is a lot of factors that we need to take into account. I feel like we have only scratched the surface. So definitely we invite Q&As on that subject. So now traveling from Brazil all the way to China on the outbound investments, the Chinese-driven outbound investments. So we are going to pass it on to Michael. Michael, you specialize in assisting clients. You are M&A expert of the evening. You specialize in assisting clients with energy and infrastructure projects in a number of jurisdictions, including Philippines, Indonesia, Mozambique, Djibouti, Inner Mongolia. Fernanda, in her presentation, noted that these sectors are ripe for investments. So for the benefit of our Brazilian audience, could you describe and outline for us, what does a typical Chinese style investment look like? How does it kick off? And what are the risks that are involved?
Well, thanks, Elisa. And I think Fernanda has given a very, very clear and concise introduction to the risks, for Chinese investors looking into investing in Brazil. I will actually spend this part of my time to explain, conversely, actually from a Brazilian either host government or a project vendor's perspective, when you're entering into negotiations with Chinese investors, or be it an open tender situation or private negotiation, what are some of the interesting issues to look out for? Not because I have to preempt this part of my discussion to say that they're not risks that are they're not high risk issues, but they are nevertheless issues that you may want to be aware of because the investors come from China. And there are 2 or 3 points I think worth talking about, and I find it very interesting. Just now, Fernanda talked about since 2017, you're seeing a lot of renewable energy, because part of my discussion is actually about renewable energy trend and some of the investors that are coming up. We are seeing actually a lot of not just the traditional power companies that are coming out of China to invest in renewable energy, but we're also seeing other industries, for example, even real estate companies who are looking into renewable energy investment, some funds, and also some EPC contractor, which is also an interesting one. And there are specific issues with this type of investors. They are good investors nevertheless. I'm not saying that there's anything specifically wrong with this type, but you just need to be aware if they come from that sort of background. And I'll go on to explain why. Now, the first thing that I would like to talk about is, as most of you, if you have dealt with Chinese investors, you might know that all Chinese investors coming out from China investing overseas need to go through something called the outbound direct investment approval procedure. It can be approval, it can be filing, depending on the type of criteria, the type of projects that the Chinese investor is going to invest in, and also, how it actually fits with the approval criteria of the Chinese government in terms of how it fits with the sensitivity of the industry, the sensitivity of the country, whether the investor's main business aligns with the new investment opportunity they're going to put into. So at most of the time, is a process that needs to be run through. 2 main Chinese authorities would be the National Development Reform Commission and the Ministry of Commerce. 90% of the time, these are not going to be issues. But when you're talking about renewable energy, I talked about a new class of investors who are coming out that may present a problem. And the reason why you need to know about these issues is not to say that you shouldn't be discussing with them, but you should actually take that into consideration when you're dealing with this class of investors. You may want to actually have a very frank and open dialogue with them about where along in terms of that outbound approval procedures they're in, and whether they may ultimately be able to satisfy all the criteria in order to close your project. So what am I talking about here? At the expense of actually jumping into some later projects here, I say with this some of these new class of investors, they may be very familiar with, for example, EPC contractor. They're very familiar with investing in offshore construction projects. That they may not be as familiar in terms of the risk associated with investing in the equity side of the project. So previously, they may be very, very used to doing 100% of a construction project, but they've never actually invested in the equity side of it. So one problem is when you're discussing certain project risk with them, they may actually look at it very differently from how you actually perceive that risk should be handled. So this is more an issue of whether they're actually familiar with the type of industry that they're in. They're familiar with the construction aspect, but they may not be very familiar with how risks are being managed. And specifically when it comes to the financing of these projects, then you may actually see some problem. And why I go into that, jumping around a little bit, is most of the Chinese investors will not be looking for international type of limited recourse financing. They would instead actually be looking at financing by the Chinese banks. And you have described, Fernando, just now about some of the situation that is happening in Brazil, for example, close to the election period. It might be more difficult for Chinese investors to get approved by these projects. Certainly, I mean, this sort of geopolitical events that are happening all around the world, whether it's due to US-China tension or whether it's due to other associated reasons, it is actually becoming difficult for Chinese investors, and also the risk of expropriation of assets in a lot of the overall countries are increasing. And this leads to issue with, for example, the insurance companies that offers political risk, whether they'll continue to be able to offer insurance in some countries. And that eventually will lead to the question of whether you'll be able to finance these projects. Simply because if you do not get the political insurance to cover this political risk, you won't be able to find financing. So oddly enough, and this works in a very interesting way about the inbound approval that you're talking about, because I'm not sure how that actually works in Brazil, but if it's similar to, say, for example, the Foreign Investment Review Board in Australia, they would look at, say, for example, Chinese state-owned enterprise a lot more cautiously in terms of approving that approval. But from the Chinese perspective, if you're talking about an investor that comes from a state-owned background, it'll be easier actually for them to get their financing. And also they will be more likely than not have the ability to actually push through with the project, rather than some of the smaller developers that you're seeing coming out of the country, investing in smaller scale renewable energy projects there. So I think there is an interesting dynamics, a bit of pull and push in how both countries, I'm talking about Brazil and China, are handling what is happening, in the geopolitical sphere with the China-US tension. So these political issues does actually have an effect on how future investments from China going to Brazil and some other overall countries will be addressed. Sorry,
yeah.
Yes, yes, I can unmute it. So, Michael, you mentioned the sources of financing for the Chinese investors include, it include usually the China Development Bank and the China Exim Bank, as well as another component that is required is, of course, to have the insurance. And the Chinese insurer, the state insurer is a Sinosure. So the insurer here is managed by the state, Sinosure, as well as the financing banks, because both of these, the CDB and the China Exim Bank, are under the direct leadership of the State Council. Does it follow then that whether or not an energy infrastructure project gets funded, then it's at least in part a political, there are some political factors into play, even if the investor is not a state-owned entity? What is your view on that?
Elisa, I think, as I've explained earlier, it's less of because it's a political reason that Sinosure refuses to offer that insurance. It's more because of the evolving situation. A lot of it has to do with the US-China tension. And why I keep actually stressing on this Sino-China tension is that there are overall countries along the overall route which may not be directly involved in that conflict. unfortunately, between China and US. But some of them may be actually taking advantage of the situation because of the vulnerability of China in the international arena when it comes to this type of disputes and conflicts. So you would have seen recently that there are situations where countries in which Chinese investors have in fact already completed the project, and where the government may come out and suddenly say that, look, this was approved by the previous government, and we do not really approve of this, so we decide not to actually honor the contract, whether it's because of a take-or-pay obligation they do not want to honor, or they may actually even want, in some cases, to deprive the Chinese government, the Chinese investor, of the assets itself. So there's a very blatant type of expropriation, and that actually raises the risk in which Sinotra is willing to take up projects in some of these countries here. So to answer your question, it's less about Sinotra or the CDB making a political decision not to advance the loan, but it's rather as a result of all these risks that are happening around the world with expropriation, whether in a very explicit form or more implicit type of expropriation, that is increasing the risk all around for Chinese investors. And that is actually affecting. Now, to be fair, I've not come across projects where the whole project has been refused because of that. But as I say, it's a constantly evolving situation. But it does actually drag on the time in which projects are getting approved in terms of financing. So you do actually need to take that into consideration if you have a tight project completion deadline. If you are the project owner or if you're the host government, then you need to take that into consideration. And the message here is, again, I mean, not to walk away or shy away from Chinese investors. To the contrary, as Fernanda has pointed out, there is a will and there is a way and there is an ability for the Chinese investor to complete the project. But it's really all about actually being aware of all these pull and push factors and be aware of it and factor that into your project timeline, and also in calculating the risk of actually being able to close that project.
Okay, thank you, Michael. Well, I think Luis is going to cover some of the aspects of what to do when there's actually a claim of expropriation, and what are the remedies that the investors will have in that scenario. So Luis is going to cover that shortly. But before we move on to that, there's one other question that we hear about often. So it will be good for you to offer some factual cases and from your experience to dispel misconceptions of something called the debt trap. The Chinese debt trap. So it's basically, as you know, as the audience knows, is Chinese infrastructure investments in developing jurisdictions usually. It has been called a debt trap diplomacy, as once indebted economies fail. The idea is once they fail to service their loans, they are said to be pressured to then support China's geostrategic interests or to cede control of strategic assets to Chinese investors. And when we were having this discussion with our Brazilian colleagues, apparently there's a perception in Brazil that when there's a Chinese-driven investment, the investors actually do not care whether or not there's a good ROI, because the point of this investment is to perhaps take control over some sort of strategic natural resources in the region. That is a what are your views of that? And from your experience, have you seen that that is the case? What are some of the facts that you can offer us?
Well, that's an interesting question, Elisa, in the sense that, first of all, the Chinese did not invent the security system. You know, if you provide a loan, it's natural to get security over those assets there. Then I think the argument is that whether you are actually lending to the right people. Now, we're not talking about actually a bank issuing a credit card to a 14-year-old. You're talking about issuing, creating a project in a country, a sovereign state. And so to say that, they are not sophisticated enough what that involves, when you borrow money, I think that in itself, I think answers part of the question. But I think more importantly, I do not, in my experience, see that Chinese deals are normally structured that way. To the contrary, in my experience, a lot of times the Chinese investors could be a little bit more they could take better care of themselves actually in terms of the investment. And just now you mentioned that in Brazil and in some other countries as well, people may think that, okay, I mean, we are going to, the Chinese are actually buying all the raw resources at all costs with ROI. Now, that is, again, something that I do not understand. I mean, if you're buying out all the resources, then there is a need for it. The return perhaps is one way to calculate it. But that's not to be all, and that's not the only reason actually for people to invest in it. All countries, other countries try to secure natural resources, and it may not actually be for commercial reasons. But again, I don't see that as the primary reason for Chinese investors to go out to invest. And secondly, I think commodity only takes up part of it. Most other investments by the Chinese investors in overall countries are in the nature of energy and infrastructure. Now, these type of assets benefit the locals no matter which way you look at it. It brings the economic activities to regions that were hitherto not made available with such resources to make them develop. And I cite, for example, I mean, in two recent cases that I've been working on, one in a Pacific nation, we're doing a Pacific island state, we are constructing a hydropower plant project. Now, in that project, I think it's not typical, especially in recent years. Not many governments will be offering take or pay without getting sufficient guarantee themselves that there will be that it is secured by a downstream off-taker. So in that particular situation, it's 100% Chinese investment. They provide 100% of the equity. The loan is actually comes from the Chinese bank. It's not guaranteed by the host government, nor the off-take itself is actually guaranteed by the government. Well, in a sense, it is. I mean, there is a state-owned company that offers take or pay, but 90% of that non-regulated tariff is actually taken up, and that's as condition precedent to closing of the project by a mine close by, which is actually owned by another foreign investor. So that pays US dollars, and that US dollars pays directly into the project account, and that accounts for 90%, if not, I can't remember exactly the percentage of the return on that project. The remaining 10% of the electricity, or 20%, goes to the locals, and they are at a regulated tariff, which is very minimum. So basically, the local residents are getting electricity almost for free, and the government itself passes on all that off-take risk over to another downstream user. So that's one very typical model that we're seeing. The other one is on an African state there. We're advising on a port terminal project. It's quite a vast project, and due to the local law requiring foreign investor not owning more than 50% of the project, the government's, one of the government's entity, 100% owned, owns 51% of the project, but they don't have the cash to pay for it. So they borrow from the Chinese investor's parent company, and that investment will only be repaid when the company becomes profitable. If it doesn't become profitable, the loan is not actually repayable, nor is it guaranteed by the government. It's actually borrowed by the SPV under the government. So again, I mean, there's all the risk actually lies with the Chinese government. It does not actually take away any resources. It is a purely commercial project in the sense that it seeks to actually secure, shipping facilities along an important shipping route for the Chinese government, but also offers opportunities for Chinese investors to set up production facilities around the port so that it can take advantage, or they can exploit other opportunities which will mutually benefit both the host country and also the investor themselves. So these are the type of investments that we typically see where, from the investor's perspective, I would have thought, they're not the best of deals, but I can see why they're doing. And one of the reasons is because of the excess manufacturing capability in China now. They need to export that, and that's a good thing actually to other countries as well, because it actually keeps inflation down. And I think a lot of countries actually benefit from it.
Thank you, Michael. You've just given us a very good, a very rich overview, not only of the Chinese investors' mindset, but also of its decision-making process. So I'm going to turn to Fernanda again and ask her about let's imagine that all this decision-making process has come to an end, and the Chinese investor is decided to invest in Brazil. At the heart of this operation, there is always going to be at least one contract. Of course, we know there are going to be many contracts: the financing, the EPC contract, supply contracts, and OGMs, and many types of contracts. So what can you tell us about Brazilian contract law? I understand there's a new legislation in place that has impacted contract law in Brazil.
Yes, Guilherme, let me give an overview regarding the legal landscape and the legal perspectives related to contractual law. I would say that there are some perspectives when we are talking about contractual law. I will evidently focus on B2B and civil and commercial contracts that are governed mainly by Brazilian Civil Code and some other specific legislation that applies to some type of contracts involved. But to give some main key issues, I would like to highlight some features so that we can have this overview of the scenario and the environment where the investor will have these relationships, these contractual relationships. So good faith is first aspect I would like to comment, and the duty of good faith applies to all contracts and requires the parties to follow I would say a fair dealing standard. And for instance, the party must mitigate loss, must inform the other parties some relevant and some relevant impact in the fulfillment of contract, and act diligently to avoid harm to counterparties. Another point to consider is the choice of law. For all domestic contracts, Brazilian law is mandatory, and as to international contracts, there is still some uncertainty. But I would say that when we have the contract has an arbitration clause, then the choice of law is expressly authorized by the Arbitration Act. The choice of venue is the other important point, and Brazilian law permits parties to choose the venue for the disputes and enforce the choice made under the contract. So there are some fewer exceptions, but the choice of venue stipulation of a foreign jurisdiction in international contracts is also acceptable, and this was reinforced by our Brazilian procedural code. And with respect to the arbitration, and I'm not going to go much further because we will have other specialists in this specific matter, but it's another important issue when we are talking about contract law, because the choice of the parties to submit their disputes to arbitration is binding, and the judiciary will not be allowed to review the merits, and Brazilian courts tend to respect and observe the existence of arbitration clauses. So it's also important to highlight that regarding the United Nations Conventions on International Sales of Goods, the CISG, Brazil has been a CISG signatory since 2014, and has not placed any reservations. I would also like to point out that in our environment, we have been dealing with electronic contracts that are a reality in Brazil, widely accepted, and as well as digital signatures. And I would say that with the coronavirus pandemic, it was also accelerated, the dissemination and use of digital signatures. Penalty clauses are widely accepted to regulate both delay of payment and also failure to comply with contract. There are some limits for its application. The penalty cannot exceed the total amount of the contract, and we can also manage with some contractual structures related to pre-liquidated damages or the possibility to claim additional damages, a non-compensatory penalty clause. So whenever we have to design the contract, these key issues are important to to be taken into consideration. We can also offer a limitation of liability clause, a limitation of liability mechanism, and unlike penalty clauses, the limitation of liability clauses require that the aggrieved party bring evidence to the extent of the damage incurred, which will be indemnified up to certain cap. A final point here is about termination, and which is evidently another essential point to consider when structuring a contract. And parties can terminate a contract based on parties' failure to comply with its obligations. And the Brazilian Civil Code does not define material breach, for instance, but it allows the parties to establish which breaches can be construed as a reason to termination. The early termination by convenience is also admissible depending on the nature of the contract, and especially when we have a contract that is valid for an undetermined term, and provided that a prior notice is given. The only key issue here is that we have to bear in mind that if some investments have been made, have been required by the other party, and the performance that the contract has not duly amortized such investments, we will have some limitations for the effective of this prior notice. So this would be briefly the main features, I would say, of the contractual, the Brazilian contractual law. And as you mentioned, Guilherme, there is a new legislation, the Economic Freedom Act. And this is a legislation enacted in September 2019, which results from a clear public policy designated by the federal government towards the debureaucratizing and incentivizing private initiative. So to briefly describe this scenario, one of the main guidelines of the Economic Freedom Act is the minimum state intervention in the development of economic activities. And how does it impact contracts, and especially how does it affect domestic environment for investors? So when we look to the contracts, the Economic Freedom Act altered some provisions from the Brazilian Civil Code, which basically deal with the judicial or arbitral revision of contracts and with the interpretation of contracts. So to provide you with a context of what we had and then what we have now, it is important to remember that our civil code contains a provision stating that contractual freedom is to be exercised within the limits of the essential functioning of the contracts. And the Economic Freedom Act brought some guidelines to avoid excessive intervention of the state in contracts through the courts, and by shortening the possibility of a revision and recognizing that it is an exceptional measure. So it starts stating that civil and commercial contracts must presumably contain parity and symmetry, and that it means that the contracting parties stand in equal positions, and therefore they are able to negotiate the terms and conditions with similar bargaining power. So it's only a presumption that can be demonstrated otherwise, but if this presumption is confirmed, then we have the following effects. The allocation of risks made in the contract must be observed, and the revision of contracts will only occur in exceptional measure and be limited to in its extent. So in fact, we have some hypotheses, and case law in Brazil has been creating a more stable environment regarding contractual issues. But I would say that this new law, it also emphasizes that these contractual matters has to deal with the autonomy of the parties to set up their own rules. Just to finalize, other important impact of the Economic Freedom Act in contractual matters relates to the interpretation, because the act introduced some new guidelines that are applicable when we have to interpret the deals, and they are not only based on good faith, but also consolidated commercial practices and are more favorable to the party that has not written the wording of the contract. So although there are some criticism against such new law, I would say that the Economic Freedom Act intends to bring more security, more foreseeability and protection to contracting investors and to the contracting parties in a general sense.
Thank you, Fernanda, for that primer on Brazilian contract law. Now, it is important to also understand what is the legal landscape governing contracts in China when there's a choice of a substantive law. For example, as you mentioned, Fernanda, in an arbitration clause, which I have encountered, and based on experience of 80% of the international commercial arbitrations that I've dealt with in the past year have been applying substantive Chinese law. So it's very important for all involved to have a sort of a working knowledge of the high level of what the principles are from the Chinese law perspective. And of course, this conversation wouldn't be complete without discussing the recently enacted Chinese Civil Code governing basically all uncivil commercial activities under the sun: real properties, contracts, personal rights, marriage, family, inheritance, and tort liability. Ben, who is our PRC law expert specializing in China-related commercial disputes, you are very well placed to help us understand what are the changes of the Chinese Civil Code that was enacted just in 28 May of 2020, so it's very recent. So can you please tell us what are the significant changes, and especially when it comes to contract law, and what is relevant to foreign investors to know? Oh, Ben, you're on the mute. You're on mute, Ben. Oh, thank you.
Thanks, Elisa. Yes, indeed. In terms of the event that had the most impact on Chinese contract law, I think the new Civil Code is the one. And it was enacted about 3 months ago by the National People's Congress, and it is not in effect yet. It will take effect on the 1st of January 2021. So we still have 4 more months to go before the new law takes effect. It is indeed a very, very important event in China's legislative life. As you rightly pointed out, the Civil Code applies to all aspects of the life of any individuals in China, but also lay down the most fundamental principles for all commercial activities. It's 1,280 articles in 8 chapters, cover topics ranging from family, succession, to contract, to security, property, tort. So it's indeed a very, very important piece of legislative work in China. But at the same time, we would also like to note that the new Civil Code is not entirely new. It is first and foremost the consolidation of many of the existing laws from various sources. And these laws, obviously, when they are put into the new code, have been either restated or reorganized or amended, and for some of them they have been completely changed. So by some rough estimate, about 20% of the new Civil Code constitute substantive changes to the existing laws. It does not mean that only 20% of your business might be impacted, depending on the relevance of the laws. Some of them may be more relevant to companies, and some of them are less relevant. I would just like to take this opportunity to walk through some of the examples which are probably more revolutionary compared to others, and which may have some impact on companies' businesses, for both Chinese companies but also international companies. And I will focus on contract law. I think the first good example is the new regime that governs third party. As many of you might be aware, Chinese law traditionally put a lot of emphasis on what we call privity of contracts. So one of the principles under Chinese contract law has always been that the contract binds only its parties. It does not create neither obligation nor rights for any third party. But the situation is now very different under the new civil code. The new civil code has introduced laws that permit creation of both obligations and rights for third parties. In terms of third parties' obligation, for example, a third party can now step into a contract to perform the obligation for one of the contractual parties to discharge its duty, whether or not there is a consent from the counterparty. The condition for the third party to do this, obviously, is for it to show that it has a legitimate interest in this contract. So I think the case law is still yet to be developed as to the interpretation of this, legitimate interest and what it would constitute. But one may reasonably presume that in a scenario such as one of your fellow shareholders defaults on a bank loan and needs to repay it, another shareholder in the same company would have a very good argument to show that it has a legitimate interest to step into this loan and pay the loan for his fellow shareholder, so that the bank cannot foreclose on the shares of the company, and the bank can be kept out of the company's business. So this is one of the possible scenario where third party may step into the performance of debt of a contract party. Another example, another example of under the new code is that the new code is now allowing a contract to also create a right for a third party, which that third party can directly enforce in its own name, unless that third party refuses to accept this right. I think another quite interesting example under the new Chinese contract law is the clauses that it has on security and also on guarantee. Guarantee, as we all know, is a very important kinds of contract that is used by financial institutions to secure their lending. In many cases, it is also commonly used by shareholders to support a transaction that one of its subsidiaries are engaging in. So it's a very important kind of support for lending. Under the existing Chinese law, as some of you might be aware, there are two types of guarantees. One is what we call the general guarantee. The other is joint and several guarantee. So basically, if you get a general guarantee, it means that if you are a creditor, you have a general guarantee. If the debtor defaults on its debt, then you won't be able to directly pursue the guarantee until you have basically exhausted all the legal avenues against the primary debtor, and until that the primary debtor has been proven to be insolvent. But if you have a joint and several guarantee, it means that once a debt is defaulted on, you as a creditor will be able to go after the guarantor directly without having any recourse against the primary debtor in the first place. You basically can hold both the guarantor and the primary debtor jointly and severally liable. So these two types of guarantees are still available under the new civil code law. What is really special under the new civil code is that under the old code, under the old contract law, if you have a contract of guarantee and the contract is silent as to whether it is general guarantee or joint and several guarantee, then by default, it is a joint and several guarantee. But under the new civil code, by default, if your contract is not explicit, then the contract will be considered as only a general guarantee. Of course, as we have just discussed, a general guarantee provides much less protection to a creditor than a joint and several kind of guarantee. So you as a lender, you as a creditor, under the new civil code will need to be very careful about the wording your contract of guarantee, making sure that it is explicitly stated as a joint and several guarantee to give yourself more protection. Otherwise, it would be a general guarantee. Yeah, another important example is the regime governing the termination of contract. As we all know, under the existing law, there are several grounds under Chinese law permitting a party to unilaterally terminate a contract if something happens. A typical example would be if the other party seriously breached the contract and refuses to take remedial actions. So these grounds still exist under the new regime. What is new under the new regime, under the new civil code, is that now the civil code is imposing a 1-year limitation period on the termination of contract. So if the right of termination of contract is not exercised within 1 year, for whatever reason, this right may extinguish. So this is indeed something that companies will need to take into account, because there are many cases where an innocent party may not want to take immediate termination action, even if the other party breaches the contract, because they may want to save the deal, they may want to save the relationship, etc. Especially if the counterparty is a very important company that they want to keep a long-term relationship. So this is also one thing that companies will need to be very careful about. Yeah, I think I will stop here.
Yeah. So Ben, that's all really interesting stuff, especially well, the last 2 points that you made regarding security and guarantee, as well as the contractual termination. I have seen a number of contractual termination cases and sort of big infrastructure projects last year in one of my cases. I am just wondering, what is the policy? Do you think that there's any policy reasons behind sort of the stricter standard and this for termination of contracts, this 1 year limitation period that didn't exist before? Is there any policy reasons behind it? Yeah, what do you see? What are kind of the implications moving forward next year?
Yeah, I think the objective really, the objective of the legislator is to maintain the stability of the contract. To the extent possible, the legislator want a contract to be kept and performed by both parties rather than be exposed to too much disruption. So that's why they are imposing a limitation period on the party, so that, you know, if a party feels that it is justified for him or her to terminate the contract, then it has to do it promptly. Otherwise, this law, this right he will lose this right, and the contract will have to remain in place between the parties. And that's probably the policy reason.
Yeah,
the stability of contract.
Stability of contract. Yeah, this is definitely something to take note. The resorting to termination of contracts is quite common from experience. And then now that this change of the 1 year limitation period is in place, so I think it's something that a client should be aware, and anybody who's involved with Chinese investors applying Chinese substantive law should be aware of these changes. So thank you very much for explaining them.
It is, well, one more point is that it is particularly relevant now that the pandemic is still not over, because due to the disruption caused to the business by the pandemic, many of the contracts are actually being exposed to this risk of being terminated by one of the parties. So this is making this new provision under the law even more relevant to all of us.
Right. Yeah. Thank you very much, Ben. So, Guillermo, do you want to take on the next point? It's the managing investment risks now.
Yes. Well, our focus up to now has been mostly on substantial law and how it impacts Chinese-driven investments in Brazil. But I'd like to invite Luis Peretti now to explain a little bit for us, way beyond the substantial law aspect of the investment, but onto the procedural level. What are the mechanisms of protection for foreign investors, and especially for Chinese investors in Brazil? Peretti.
Thank you, Guilherme. Well, when you think about investment protection tools, there are many ideas that come to mind, but let me begin with investment arbitration As you may know, some countries undertake obligations under international law to provide certain protections to foreign investors. And this is done in order to promote investment into that jurisdiction. That is done via international treaties that offer such protections. In substance, the host country can promise that it will treat that investor as a national of that country. It can provide other standards of protection. And as Elisa mentioned earlier, one of the common guarantees that are included in such treaties is that the investment or the investor's assets will not be expropriated or nationalized without due compensation. Of course, consider the situation in Brazil. We do have laws, domestic laws, that provide that expropriation must entail a due and prompt compensation. But an investor would have to sue the government before Brazilian courts in order to enforce their obligation. If you have that obligation also stated in a treaty, that provides an extra level of protection for investors. And normally, besides those substantive protections, those rights that I'm mentioning, such treaties also allow the investor to sue the host country through arbitration in case of breach of said promises, and to obtain redress for any breaches of the treaties through arbitration. It is interesting to note that China has done 145 of such treaties, many of which provide for investment arbitration, including 9 treaties with Latin American jurisdictions. Brazil, on the other hand, has not been very fond of using international treaties to try and attract investments. During the 90s, we did sign 14 of those treaties, yet none of them was ratified. Since 2015, Brazil adopted a new generation of treaties, and until now, we have signed 13 of those treaties of the new generation, but only the agreements with Angola and Mexico came into force. Yet, such treaties do not provide for investment arbitration either. As a result, Chinese investors that come to Brazil cannot benefit from investment arbitration since Brazil has no treating force allowing that possibility. On the flip side, foreign investors that go to China may benefit from protections applicable to their country of origin. And the reason why I wanted to bring this up is because many Brazilian companies have now gone global. For Brazilian companies going abroad, it is then very relevant to consider that certain hubs for international corporate structuring, such as the Netherlands or the Luxembourg, have done BITs with China, and even our sister nation of Portugal. Therefore, the Brazilian companies doing business in Asia should check what would be the best corporate structure to maximize the protection available, and also to include that extra protection, for instance, for expropriation that we just mentioned. So, but for those who invest in Brazil, the alternative used to enhance certainty that is currently used is commercial arbitration.
So then Luis, can you tell us then how can the commercial arbitration help protect investments for Chinese investors as a good substitute to investment arbitration, which is not an option?
Yeah, sure, Elisa. Well, you have put the question quite correctly. It's being used as a substitute. Since we do not have investment arbitration, the Brazilian government and also private investors have been using arbitration as a way to add an extra layer of foreseeability and certainty for their transactions. And arbitration is helpful to that end for basically 2 reasons. First, the parties will select who will sit as arbitrators instead of relying on public officials to resolve their disputes. Therefore, arbitration will offer a more specialized dispute resolution mechanism that is conducive to results that are more adequate with the party's intent, and this leads to more foreseeable results. Second, arbitration also offers increased neutrality in comparison with local courts. The Brazilian nationals listening to this webinar may be thinking that, well, this is irrelevant because in Brazil, the judiciary is sufficiently independent from the executive branch and works properly. However, that may not be the case concerning foreign investors, especially with regards to contracts entered into between private investors and the public administration. And this is why, since the 1990s, arbitration has been authorized in several regulated sectors in Brazil, such as telecom, transportation by water, telecommunications, electricity, oil and gas, etc. The 2004 Brazilian PPP law also provides that disputes relating to the concession of the public partnership can be resolved through arbitration. And Brazilian courts have followed suit. They have been very supportive of arbitration. And in 2015, we even had a reform of the Brazilian Arbitration Act, quenching all remaining doubts and stating that Brazilian public entities can, and in a way, it implies that they should rely on arbitration to resolve disputes. Of course, if you are contracting with a public entity, this arbitration proceeding will have some special features. A decree issued in last year, in 2019, by the Federal Public Administration, applicable to the Federal Public Administration, provides that the arbitration must be in Portuguese language, must have Brazilian law applicable to the merits, and the seat must be located in Brazil. And besides, as Fernanda had put, we have 27, in short, state entities, the federated states that may also have laws that provide certain features to that arbitration proceeding. And this trend of usage of arbitration is expected to continue. Nowadays, the oil concession and production sharing agreements that the Brazilian National Oil Agency executes in order to regulate concession projects, they provide for institutional arbitration. The institution should be chosen by the agency and the concessionary together. And in case they fail to reach agreement, the contract provides that they'll have the choice between the ICC, the LCIA, and the PCA. Another trend here in Brazil is the usage of dispute boards in order to increase certainty as a project develops. And it's interesting to note, those who have read Mr. Neil Kaplan's biography, Mr. Neil Kaplan was a former chair of the Hong Kong IAC that Sarah Grimmer represents and gives us the honor of co-hosting this panel today. He wrote in his biography, he wrote about the dispute resolution board that was created in Hong Kong during the 1990s in order to oversee the construction of the new Hong Kong International Airport. It has taken some time, but Brazil has followed suit in the usage of dispute boards, and São Paulo enacted a law in 2018, the city of São Paulo also authorizing the usage of dispute boards. And we have nowadays 2 bills before Congress regarding dispute boards that may come into force shortly. And so just to conclude on this point, when you talk about private investors, it's also interesting to note that Brazilian law also provides that corporations may include arbitration in their bylaws to resolve disputes between the shareholders and the public administration. So this gives the investors lots of choices of mechanisms in order to increase the certainty and foreseeability for their contracts. Just an additional point to conclude with regards to arbitration, regarding the seats. Well, from the Brazilian standpoint, parties are free to choose either countries. Arbitration in Brazil is doing fine. We have specialized courts that support arbitration. And also, Brazilian courts have been very supportive of arbitration when they enforce awards rendered abroad. In 2013, Professor Albert Jan Vandenberg wrote an article praising the way that Brazilian courts have been applying the New York Convention. So if you are a foreign investor looking forward to do business in Brazil, you have the choice of either arbitrating in Brazil, at least in one of the major cities that shouldn't be a major issue, or arbitrating in other jurisdictions, provided, of course, that the New York Convention applies and that you trust that legal system.
And thank you, Luis, for that. And that actually, it's a good segue for Sarah here, that we have Sarah Grimmer from Secretary General of the Hong Kong International Arbitration Center to talk about Hong Kong as a seat. And this is a particularly relevant issue, a topic right now, given in light of the protests that rocked the city last year, and most recently with the national security law, which some commentators have indicated that it erodes the one country, two systems and compromises the judicial independence and integrity of Hong Kong. So how do you respond to that, Sarah?
Thanks, Elisa. You're right that there has been a lot that's been happening in Hong Kong over the last 12 months, and it's led to quite a few perceptions about Hong Kong and questions as to whether or not Hong Kong remains a neutral and effective seat, especially with respect to disputes between Chinese parties and non-Chinese parties. And at HKIAC, we see a lot of those kinds of cases. What I can say is that the national security law that was passed 2 months ago is a new law, obviously, and it defines 4 criminal offences related to national security, which are secession, subversion of state power, terrorist activities, and collusion with foreign forces to endanger national security. It's a law that is 66 articles long, and it's embedded, of course, within the one country, two systems context and constitutional arrangement of Hong Kong, which is relatively complex in and of itself, and therefore requires understanding to really understand what the impact is of the national security law, especially given that it is so new. But rather than getting into those details, because they are so complex and so layered, what I would like to convey is that in Hong Kong and in mainland China and internationally, there are very many views about the national security law. In Hong Kong, there are many strong proponents for the national security law. There are many people with strong views against the national security law and everything in between. And in Hong Kong, these issues are debated at length. There's a lot of attention and there's a lot of discussion going on. So what do Brazilian parties that are choosing a seat and thinking about whether or not Hong Kong is appropriate in their dispute with a mainland Chinese party, what is important for their considerations? I think what is important to know is that the national security law and the protests that preceded it last year have no impact on the legal framework that exists in Hong Kong relevant to arbitration. And so I just want to talk about a few specificities around the legal framework that's relevant to arbitration in Hong Kong. And I really want to bring to the attention of Brazilian parties a new development, which is absolutely important for their consideration when they're considering Hong Kong as a seat. So what are the peculiarities or what is particular about Hong Kong? As everybody knows, Hong Kong is a common law jurisdiction. It's a separate legal jurisdiction within China. It is like a mini London within China in terms of the legal jurisdiction. So the law is based on English law. The arbitration ordinance is based on the ancestral model law, and the Hong Kong courts have been interpreting the ordinance for many years. Arbitration is very well known in Hong Kong. It's a very established dispute resolution means, and my friend Luis alluded to Neil Kaplan's book and some of the very early big arbitrations that took place in Hong Kong around the mega projects that have happened in Hong Kong. When an arbitration-related matter is submitted to the Hong Kong courts, it goes before specialist arbitration judges. And in Hong Kong, you have to understand that you have Hong Kong judges, and you also have foreign judges at multiple levels of the court structure. So the specialist judge in charge of the arbitration list is a Justice Mimi Chan. She was originally born in Brunei. She's a former partner of a global dispute resolution specialist firm, and she's been issuing case law that is predictable. It's a matter of record for many years, and fiercely pro-arbitration. It's not uncommon, for example, in Hong Kong, for the Hong Kong courts to injunct proceedings elsewhere, other jurisdictions, including in mainland China. It's not unusual for the Hong Kong courts, it's not a matter of controversy for the Hong Kong courts to enforce arbitration awards, for example, against the Hong Kong government, against mainland Chinese companies, including mainland Chinese state-owned enterprises. And one very important judgment in this respect came down quite recently in 2017. And that is not necessarily a legally controversial thing if the state-owned enterprise that you're talking about is operating like a commercial entity, even though it comes under a state administration of SASIC. Also, what's unique about Hong Kong, you don't find elsewhere in the world, is that the court, the apex court, the highest court, is constituted by 23 judges, and 15 of those judges are foreign judges from the most eminent courts in other common law Commonwealth jurisdictions, including the United Kingdom, Canada, Australia, and New Zealand. And the most recent appointments to that court were Lady Hale from the UK Supreme Court, the former president, Lord Sumption QC, and the former Chief Justice of the Supreme Court of Canada, that is Beverly McLaughlin. So there's really some incredible eminence on the court alongside the Hong Kong judges that are on the court. Then when you're thinking about the framework, you have to also think about the institutions. And so what about HKIAC? Well, HKIAC is one of the top 4 commercial international arbitral institutions according to the Queen Mary survey. We are a truly international arbitration center. Our governing structure is transparent and it's populated by many international dispute resolution specialists, as well as local specialists. And of course, we must have mainland Chinese specialists on our decision-making bodies and within our governing structure, because so much of our work is about international disputes coming out of mainland China or involving mainland Chinese parties. Now, when I started to speak, I mentioned that there is a very important development that the audience should know about, and that is the interim measures arrangement, which was concluded in 2019 October. And what that arrangement does is it means that if you choose Hong Kong as a seat and your arbitration is administered by one of a handful of arbitral institutions, of which HKIAC is one, you are now able to access the mainland Chinese courts for interim relief for the preservation of assets, evidence, and conduct. This was not possible before unless your arbitration was an onshore mainland Chinese arbitration. But now you can choose Hong Kong and you can have your case seated outside of mainland China. Hong Kong is the only seat where this is an option, and you can get direct access to the mainland courts for interim relief. We have been kept quite busy with this new instrument. We have seen 25 applications made under it. All of those applications, bar one, have been with respect to the preservation of assets. The total amount that has been sought for preservation covers $1.4 billion worth of assets on the mainland. And the amount that has been granted comes to $1.3 billion. So we see mainland Chinese parties and foreign parties using this instrument to freeze assets at the beginning of the arbitration to ensure that if they get a successful award at the end of the process, they can enforce. And that, of course, is the entire point of an arbitration proceeding, is that you can enforce if you have a successful award. So I think what I want to, as a takeaway, what I want to say is that there's a lot of talk about neutrality, how things function in Hong Kong given the national security law. You should know that most things function exactly as they did before, that there are deeply embedded rules, structures, and institutions in Hong Kong, and it would be a mistake to eliminate Hong Kong as a seat based on perceptions, based on just what you read in the media, and that if your interests at the end of an arbitration are on the mainland, whether they're possessed by a mainland Chinese party or by a foreign party on the mainland, then you really do need to consider Hong Kong as an option, because you can protect the ultimate interests of an award. Thanks.
Thank you, Sarah. Well, we've heard about the dispute resolution environment in Brazil, in Hong Kong, but I'd love to turn to Ben and hear a little bit more about China. Because anyone who's been watching China closely for the past 3 to 4 decades has certainly identified a monumental change in its rule of law. So Ben, what can you tell us about the evolution of dispute resolution in China, and more specifically, can you tell us whether China can be considered a arbitration-friendly jurisdiction? You're on mute.
Yes, indeed, Guillaume. I do believe that China is an arbitration-friendly jurisdiction. China's arbitration law has been around, applicable in China since 1994, and China actually has a good record of recognizing and enforcing foreign arbitrations in China. And this is often against the intuition of some of the observers outside China. For example, in the past, there has been a lot of concern about Chinese court might refuse the enforcement of foreign award on the basis of public policy. But actually, since 1984, there have only been 2 or 3 cases where Chinese court indeed refused the recognition of a foreign award in China, and the latest one being already more than 10 years ago. So China is indeed a legal system that supports arbitration. And you probably also heard about the creation of the new international commercial court by the SPC. The SPC has created this institution, and one thing that they are very proud of is what they call one-stop dispute resolution platform. Basically, on this one-stop platform, the SPC has brought together a selected group of arbitration and mediation institutions so that they can work closely with the SPC on international commercial cases. And if your case is eligible, meaning that if the value of claim is more than 300 million and you bring this case to one of those partner arbitration institutions, the parties can have direct access to the SPC, the highest judicial authority in China, for judicial support, in particular the preservation of evidence, preservation of assets. So this is yet another example showing the support that the parties can get from Chinese court. In terms of Hong Kong arbitration, I think Hong Kong remains, as Sarah rightly pointed out, Hong Kong remains to be a very popular place for resolving China-related disputes between Chinese and international parties. I think Hong Kong occupies a very unique place. It has a lot of natural advantages to be very well placed to resolve China-related international disputes. Culturally and geographically, it is very close to China, so appeals to Chinese parties. But its common law system, its English language, also appeals to international parties. So it is still a very good middle ground that is easily accepted by both Chinese and international parties. I mean, I think these advantages for years to go, for years ahead, will not go away. And Hong Kong, whether or not and in whichever way the national security law will be applied in Hong Kong, I mean, these natural advantages that Hong Kong have will simply not go away. And it will still be a very attractive place, a very popular platform for dispute resolution, in particular for arbitration, for both Chinese and Brazilian parties, I believe.
Thank you so much, Ben. It's a very clear view about the situation in mainland China regarding dispute resolution. I would like to go back to Sarah. we're a little over time now, but we received some questions from the audience. And one thing that keeps popping up, Sarah, regards the virtual hearings. I know this is something a little apart from the topic of investment, Chinese investments in Brazil, but I wouldn't miss this opportunity to ask you about the HKIC's experience with virtual hearings, especially now in times of COVID-19, and how do you see the virtual hearing into the future? Let's imagine a future in which the vaccine is here, everything goes back to quote normal, but what is the role of a virtual hearing in the future, according to your experience in your views?
Yeah, thanks, Guilherme. So this year we have seen a real spike in virtual hearings, obviously because of the pandemic. So we've held 69 hearings this year. We didn't close down our premises because we didn't need to. We took precautionary measures. We could continue our operations in Hong Kong. The situation was relatively better than in some other jurisdictions, which allowed us to do so. So we have held 69 hearings to date, and 60% of those hearings were virtual, either partially or fully. And in April and May, 85% of our hearings were partially or virtually or fully virtual. And we've seen a real range of cases, from your very straightforward situation where you have one person dialing in and everyone else is in the same room, through to, for example, a 10-day full merits hearing, which was across 9 different cities, multiple time zones, 11 witnesses and experts, joint conferencing, simultaneous interpretation, court reporting. And so it was, you know, as complex as a merits hearing will get. We've also had a construction case that has gone on for 40+ days, and that has been partially virtual. So the demand has been very strong. And I think, and looking forward, when we look forward to through to the end of the year, we have 97 hearings booked. That will increase with time, and 60% of those hearings require partial or full virtual hearing services. And we've also been helping some courts with their proceedings. So there's a real demand this year. It's very strong. But what I think going forward, and I think a lot of us think this, is that the parties are becoming more and more comfortable, the tribunals are becoming more and more comfortable with technology, with the platforms, with the privacy, security and confidentiality of these proceedings, and how you can control those aspects, and the incredible savings of costs, the incredible savings of time, and the fact that the availability of arbitrators is now much more fluid and flexible. So I think it's going to carry through to the future. There's no doubt. We've invested in upgrading one of our large hearing rooms into a dedicated virtual hearing space, and we will launch that in a couple of weeks, actually next week. And so I think I think we're seeing a real shift in how we'll do things.
Thank you, Sarah, for that. With that, I think we have ran out of time. This was a really substantive discussion. I feel like we've covered a lot and also traveled, from the laws of Brazil, to inbound investments in Brazil, to outbound investment in China, and of course, from the contract law perspective, from the managing the risk perspective, as well as from the institutional perspective. So we definitely cover a lot of grounds tonight in that hour and a half. So we're slightly over time, so apologies on that. Of course, if you have questions and if you want to actually rewatch this, you can. It's been recorded. And if you or any of your contacts have any advisory questions on any of the topics that you hear so far, of course, Souto, Correa, as well as Funda partners are here to help you. So feel free to get in touch, and thank you very much. It's been a great discussion. So thank you to our panelists, of course, and good morning, good afternoon, and good night to everyone who's in Asia. Thank you. Bye.